Great. And so we're going to start by hearing from Senator Darneille, who's going to share some opening remarks. Then we'll turn it over to Carla and then Orlando, and then we'll open it up to questions from the media. I am going to be working to give folks recording permissions right now as well, but just so everyone on the call knows, I'm going to be sharing a recording of this after the call in case you have any difficulties recording on your end. But we should be good to go. So I'm going to turn it over to Senator Darneille to kick things off. Thank you.
Great, thank you very much. Well, I'm Jeannie Darneille. I'm a state senator from Tacoma, and that's the 27th Legislative District. And I also chair the Human Services Reentry and Rehabilitation Committee of the State Senate. I have had a very long interest in this issue and have made attempts over the years, along with prior colleagues, to amend the three strikes law. And so we have done a couple of fits and starts with that. And this is a good cleanup bill on a major bill we passed 2 years ago. So I am delighted to be here. And I also should say I serve on the Sentencing Guidelines Commission as well. So have a chance to rub elbows with a lot of the folks that really understand how this kind of policy can affect our state.
Great, thank you. Carla, do you want to go ahead?
Yeah, thank you everybody for coming, and thank you Douglas and Casey for setting this up. And I want to give a special thanks to Senator Darneille, just because you have been instrumental in pretty much mandating the work that I do for the prosecutor's office, and I've been doing for the last 8 years, as far as sentencing reform work and clemency work, and now sentence review work. I also want to say I feel honored to be here with both of you. Orlando was one of the first cases that I worked on that I reviewed for clemency. I had met Orlando at Monroe. I was really impressed with his rehabilitative and transformational path. And then when we reviewed his case for clemency, we also identified that based on our current practices, we probably wouldn't have charged him with a strike offense. We probably would have charged him differently in order to avoid the three strikes law. So it's an honor to be sitting here today with the two of you who have, in your own way, been advocating for a long time for this day, for this bill. And I'm just extremely appreciative of just all the work that so many people have done. I know that when I first started in the office in 2013, Adam Klein and Jeannie Cole-Wells, and then you, Senator, and now Monka Dingra, and even some of the local leaders like Larry Gossett have always been talking about the three strikes law and how we needed to do things differently. So today with 5164 now being the law, it puts me in a situation as someone who's been one of the leaders in the office working on this work on three strikes cases in particular. It puts me in a position where now we can start to quickly maneuver these cases through the system, through the judicial process, and not having to use the clemency process to try to come about a more just outcome. So I really appreciate your work, Senator, and I really appreciate you being here too today, Orlando. And I look forward to answering any questions in the room today. Thanks for inviting me.
Good afternoon, everyone. My name is Orlando Ames. I'm the Reentry Director and a care coordinator for the Freedom Project. I was actually directly impacted by this second-degree robbery charge initially, because had it not been used as a strike, instead of a sentence of life without, I would receive 22 to 29 months. I'm glad that there's a possibility for relief now for those that are directly impacted initially.
There's still more to be done, a lot more work to be done, because it's long overdue. It took me 21 years to come home due to clemency, but that was just one way, one option of getting out, and everyone does not have the option of going before clemency. So to make this bill possible is a really great thing. And I will pass the floor back over to the senator.
Well, Doug, where do you want us to go from here? I could talk a little bit about the history of this bill and put it in some context if folks would like that. Of course, everyone knows that the Three Strikes Initiative passed with overwhelming public support back in, I think it was 1993 or 1994. It was the first three strikes law, persistent offender law in the country. And of course, many other states have followed in our path. So this is not just an issue that affects people in Washington state, but all across the country. And it has proven itself to be very racially disproportionate and demonstrates some of the real inadequacies in our justice system that would result in a person receiving a life sentence for something like a robbery 2. It was back in 2004 that the Sentencing Guidelines Commission first raised the issue of sort of like if you're watching Sesame Street and you're singing that song about one of these things is not like the other, one of these things just doesn't belong. I won't sing it for you, but in this case, robbery 2 and assault 2 were identified as just that, not like the others, and certainly not consistent with our goal in the initiative, or the goal in the initiative, to place behind bars for life a person who had been a persistent, violent, and violent offender in the state. So there were flaws in the initiative, and we've been attempting to fix those now for many years. And Carla, I appreciate you mentioning former senators Adam Klein and Jeannie Cole-Wells. I was able to work with both of them when I first came in the Senate, and I certainly have been in a position when I was a House member to be working with now retired Representative Eric Pettigrew to try to bring this issue forward time and time again. I was a member of the Law and Justice Committee over in the House for many years, and Al O'Brien was the chair. I don't know if that's a name that anybody can remember, but Al was a former Seattle police officer who then became the chair of this committee. And he really wanted to change this law. And I can remember being on the committee one year where on the very last day before cutoff, Representative O'Brien had a hearing for yet another ideation of the bill that's before us today that was to remove robbery 2 and assault 2 from the Three Strikes list. I have never been in a hearing quite like that. It was jammed. Every available space along the wall was filled with people. Every seat in the place was taken. And it was family member after family member telling the stories about their incarcerated loved ones who had committed a robbery 2 or an assault 2 and were now spending their lives in places like Monroe. And I leaned over to Representative O'Brien and I said, Al, and I had never heard this kind of emotional, deeply resonating stories from a hearing before. I was pretty green at that point, if you can imagine that long ago. But I leaned over and I said, we've got to pass this bill out. We've got to pass this bill out of committee. And he says, well, you know, we can't do that. We didn't put it on the exec list. The Republicans don't know we're going to vote on it. There's just no way, Jeannie. There's no way we can get this out of there. I said, oh, Al, we've just got to. These people are waiting for, you know, some sort of hope here, and we've got to be able to pass this out. And I turned to the other 2 Democrats on the committee. I said, don't you agree? You know, don't you think we should? And they're like, yes, let's vote this out. So Ruth Kagi was another member of that committee, as was Steve Kirby, and we went ahead, and as was Velma Valoria, and we went ahead and voted that bill out of committee. Well, you would have thought the tower had come down at the legislature, the rotunda. It was like all kinds of screaming and yelling about, you can't do this, and cheering from the audience. And then, of course, we did find out that we couldn't do that. We didn't give the public notice about, about the executing of the bill, and there were all kinds of problems. So it didn't move anywhere from there. But it was a moment for me where I really understood the gravity of the situation and the stakes, the high stakes, and how obvious it was that this was an issue that was hurting brown and Black people in our state more than white people. And so we've been working on this issue, and I think that 2 years ago when we finally got the bill passed, you mentioned Senator Dingra, she certainly came into the legislature with you know, such a breadth of experience, over 20 years experience prosecuting people. And when she came in and said, this is important to deal with as well, I really had the backup I needed. And we had to make some decisions 2 years ago to get the bill through. And one of them was pulling assault 2 off the list. And secondly, it was making the bill prospective only, and not addressing the issues that were of concern to the prosecutors at the time, that they have truth in sentencing, and that these were people that were serving time now, serving life sentences now, and they didn't feel it would be appropriate to go back and resentence people. So that was desperately hard for me to take. But in the legislative world, some of the most important bills we ever pass have been done so in an incremental fashion. And so I wanted to get a crack in that 3 strikes law. I wanted to be able to start this process of analyzing whether or not this is in accord with our values as a state today and is appropriate in every way. So we thought at the time that bill passed 2 years ago that there were something in the middle of maybe 60 to 70 people in prison that would be affected by the bill. But when we brought this bill forward this year, the Department of Corrections went back and really did a deep dive on data and found that actually since 2 years ago when the bill passed, that there were 114 people that would be affected by this legislation. And Orlando, maybe you're one of these 9, but 9 people in the last 2 years, because the first bill had passed, were able to go back and receive clemency for that offense that they had been convicted of. But that still leaves over 100 people that are in prison today that will now, because of this bill, be able to have a resentencing process and have their cases reviewed. And hopefully will be, many of them will be able to leave prison. And if not now, then at some point in the future. So I want to just say, I want to thank so many of the partners that have really come together and worked with me on this bill. The sign-in sheet for, we're a virtual session this year, so it was super strange. But the sign-in sheet included just literally dozens of organizations that were supporting this, and really represented by a lot of organizations that are advocating on behalf of people of color. And I really am thankful for that. And I'm thankful for the Washington Association of Prosecuting Attorneys, which had largely opposed my bill 2 years ago until we made it prospective only, and then came back this year because of the work of prosecutors like yourself, Carla, who have gone back and undertaken the clemency process with people, which is very laborious. It's volunteers that are on the clemency board, takes forever to get through that process. We've come a long way, and I think this will result in a lot of people being able to return to their families. So I'm very excited about that. So I'm happy to talk any more about sort of the political, fractures and partnerships that were built across the many decades of people having concerns about the 3 strikes law. But I believe it's an incremental step towards justice.
Thank you so much, Senator. And for the reporters, producers who are on the line, feel free to either jump in with questions or drop your questions in the chat and we can take them one by one. While that's cooking, I have a question. So I'm wondering, Carla, from your perspective and your work as the chair of the Sentence Review Unit, when are you kind of anticipating some of these cases to start moving forward under this, under this new authority? When do you think we'll start seeing some of the 3 strikes, Rob 2 cases start being resentenced?
Well, that's a good question, Douglas. Thank you. You know, last year there was another bill, and I know Senator, I think you were a part of this one as well, 6164 passed, which it gives prosecutors the ability to resentence in the interest of justice. So because our office has been engaged in a sentencing reform effort ever since Dan has been our leader, so starting in 2009, we've been focusing a lot of our efforts on 3 strikes cases where one or all of the strike offenses included a robbery and a second-degree conviction. And so when I came into the office, about 2 years after I had come into the office, which was 2013, in 2015, I inherited a list. It was a list of originally 45, but by the time I start working off this 3 strikes list, it's a list of 40, where leaders in our office had undergone a review of a handful of 3 strikes cases and identifying them as cases we could potentially support in a clemency petition. I inherit that list. Moving forward, we're using the clemency tool and the resentencing tool, absent 6164, to start focusing and trying to get relief for these 3 strikes cases. Then just last year, 6164 passes. We basically take the people that are left out of that 40 cases. There's about 21 that are left, and the others we had supported in clemency, and we put them on what we call the 6164 list. And then as we heard about 5164 this session, we started to look at those cases again. They all had a robbery in the second degree that resulted in their being struck out under the persistent offender law. So then many of those folks are now a part of what we're calling our 5164 list. So now that the law has passed, what we've done is we've started to connect with all of those individuals that have counsel. We've met with counsel, we've identified, let them know that we've identified, we have what we believe is our list. But now that Senator Darneille has mentioned that there's actually a few more folks that will be impacted, we'll have to get our numbers updated from DOC to make sure that we have the accurate number. But as it stands now, we've identified 29 individuals that we believe will be eligible for a resentence under 5164. And we've started the process by contacting both counsel. We've already reached out to victims under the 6164 analysis. We were already doing that. And we've also reached out to the court to let them know that these cases will be moving forward. So we've already started the process, even though the bill doesn't become effective until July, 90 days after it has passed the legislature. So it won't be effective until maybe possibly July 25th, I believe. I could have that date wrong. But we wanted to get the process going because, as you all know, there are other changes in the law that will bring about resentences as well. And with the Blake case and then our COVID queue, we'd like to get going on these matters as soon as we can. Thank you, Douglas, for that question.
Thank you. And so Nina, I think we addressed Nina's question in your comments, Carla. She was asking how many cases in King County will be resentenced because of this bill?
Yeah, we believe 20, we identified 29 prior to Senator Darneille mentioning the 114 that's been reduced to about 100. So we'll have to check with DOC to make that 29 is accurate. But as of now, we've identified 29 cases.
You know, one thing that people might have an interest in is some of the demographics of that group. I'd be happy to share that. And they also might be surprised at how many people of those 114 have more than one robbery two on their record. We had the case, for instance, of a woman who's been out at Purdy, and all three of her strikes were robbery two. You might also be surprised that there are several people serving life sentences who have more than three strikes, more than three robbery twos on their record. And you might ask, how the heck can that happen? We thought it was three strikes, you're out. Well, what happened back in the mid-90s when the initiative passed was that the initiative was prospective, but the legislature came back and made it retroactive. And so in that case, people who had committed crimes in the 70s and 80s may have committed a crime in the mid-90s and suddenly found out that they were going to be in prison for life, because things that they had done prior to the initiative now were stacking up as strikeable offenses. And it just took this additional time of incarceration to move them over the finish line, if you will, and turn that into a life without parole. And so 33 of those individuals, of 114 individuals, 33 had more than one robbery two on their record. That's 29% of the people that are in prison for life have more than one robbery two. 20 of them had one additional robbery two. 8 had 3 robbery twos. 3 had 4 robbery twos, and 2 had 5 robbery twos. Again, mentioning them because these were crimes before the retroactivity of the initiative was placed on them. Of the 114, 111 are men, 3 are women. 11 are over the age of 65 today. And you have to think back to that mid-90s where the census of people in prison for life jerked forward rather quickly, rose rather quickly because of the initiative. I already said there were 9 that have received clemency. And I'm going to tell you a little bit about the racial demographics if I can. Only 50 of the 114 people are white. Of the 9 people, though, that have received clemency, 6 were white. So already we see the importance of the clemency process because it was some form of post-conviction review, but it is not ideal. And I think those demographics of the people who were able to secure clemency speak volumes. Of the 114, that leaves 64 that are men and women of color, 6 Hispanic, 53 African American, 4 American Indian and Alaska Natives, and 1 Asian or Pacific Islander. I come from Pierce County, so Carla, I had to kind of hone in on how many of these cases were from Pierce County, and it was about 20% of the cases are from Pierce County, and so your 29 or so you might have in King County, our 2 counties make up almost half, I would say, of the people that are serving life without possibility of parole. So that gives you more of a demographic look, and I'd be happy to answer questions about that data as well.
I think, Paul, you had a question. You were going to chime in via mic, and then Jack, go ahead, and then we can take Paige's question.
Yeah, I do, and it's a pleasure to be here. It's actually a question about last year's 6164, and I have elements of the question for Senator Darneille, Orlando, and for Carla Lee. So given the really slow pace of implementation of 6164, I think only something like less than a half dozen people have actually been resentenced because of that bill. Senator Darneille, do you have a plan, or do you expect at some point for the legislature to revisit the notion of prosecutorial discretion to more narrowly define or clearly define who is eligible for discretion to, pick up the pace of resentencing under that bill?
Sure, Paul, you've just hit the nail on the head. 6164 was supposed to give prosecutorial discretion, but when it really went out and the boots got on the ground and started to try to implement it, there were prosecutors. We have to remember, we have 39 counties, 39 prosecutors, elected people looking at their voters. And so some of them may not want to implement 6164, and others saw it as not fully clarifying enough for them to be able to implement it without with the surety that they were following the law. So that in itself has opened up the possibility for 5164 to even pass, because we want to have equal access to justice in our state, and we can't abhor, can't live with laws that have ingrained in the implementation of those laws disparity and making more inequitable systems. And so if you have counties where the prosecutor felt they didn't want to, or they didn't have to, then they didn't go ahead and implement 6164. And so this law makes it quite clear that they will review those cases and they will resentence those cases. So, and like Blake's decisions, points will be reapportioned, and I'll let Carla explain how points come into all the action. But I think, Paul, you're absolutely right that this will increase the number of cases that will move forward.
Thank you. And for Orlando and then for Carla. Orlando, in your work kind of in advocacy, what concerns have you heard from inmates about the pace of implementation of past resentencing initiatives, and concerns about how these laws might be applied inequitably, county to county?
Frustration, literal frustration. We already know progress is a slow process to begin with, and then when it comes to politics, it makes it even slower. The only thing that we tell them to do is we can just continue to push forward and remain patient, because this is the process that's in place right now, and nothing will make it move any faster. They always say the wheels of justice turn slow, but it's almost like a dead stop, basically. And when you're on the other side and you're sitting in there, you're looking for any semblance of hope that'll continue to move things forward. And unfortunately, the only thing you can do is hurry up and wait.
Right. And Carla Lee, if I may, would you be able to talk through King County's process for defining eligibility for 6164? And I know that there was it's not drawn from the state legislation; it was created by your office, I believe.
Yeah. So for our office, since the passage of 6164, we have reviewed over 234 cases. It may be a little more. We did create the unit that I'm the chair of, the Sentence Review Unit. One of the barriers that we ran into was the pandemic hit, and then we received a word from our court not to bring these particular petitions forward because there were other more pressing issues and operational issues that the court needed to address prior to addressing these more discretionary sentences. So we have been working to try to implement 6164, and we even developed our own sentence review guidelines. And to answer your question, what we did is we identified priorities and non-priorities. And some of our priorities are controversial because people didn't believe that 6164 allowed you to undo a 3 strikes sentence. But in our priorities, consistent with our sentencing reform efforts, 3 strikes with the robbery 2 was one of our first priorities for 6164. Non-homicide cases where the person may have received 20 years or more, and they may have been under the age of 25 at the time that they committed the offense, was another priority category. Justified self-defense claims that weren't presented at trial, the women's battered syndrome, the child battered syndrome, immigration consequences. Those are some of the priorities that we had identified in our guidelines, and we can make our guidelines available. They've been a work in progress for the last year, but they have been finalized, and we're happy to share those guidelines with people. I know that we've been sharing our guidelines with other prosecuting attorneys' offices, not only in our state, but around the country, because other offices are interested in doing this work. And some offices such as, I think we have Chicago that's reached out to us, LA, San Francisco, Maryland, have reached out, and we've shared information with them about our process and about our guidelines. And so does that answer your question? Did I get to everything?
Yeah, it very much does. And I'll reach out to get a copy of those guidelines after this. Thank you so much.
No worries.
All right, Jack, did you want to jump in?
All right, can you hear me? I think I'm unmuted.
Yep, we can hear you.
All right, thank you. This question, or I guess kind of pair question or a couple questions, is for any and all three of you. So thank you for being here to chat and for answering this. And so the Senator Darneille, you've mentioned how this was like kind of an incremental change, and I'm curious why people have been resistant to this change for so long, and why this kind of reform, is resisted, and then if kind of all the unforeseen consequences as this law has been tweaked incrementally, if now you think that they've all been addressed. And that can be again for any three of you.
Well, the passage of 5164 is really a testament to the statement, the majority matters. This bill passed without any Republican support, and it's only because of the healthy majorities that the Democrats have that we were able to move any of these three bills forward, quite frankly, in the last 3 years. And watching the hearings or the floor debate and living through them myself, you have to gird up to listen to the types of arguments against this bill in particular, but also any kind of bill that purports to address systemic racism in our state. And so we have just weathered the 105-day session, and I had way too many opportunities to hear the kinds of arguments against this legislation. And they range from, well, you wouldn't have to do all this time if you just quit committing crimes, and just statements that are extremely racially laden, where people don't want to look at demographics. They don't want to say that demographics matter because they don't want to be reminded of how, or have it shown to them in clear language, that this practice of keeping people in prison for life is so expensive. It's expensive financially, but it is expensive to our society because we're losing good people, people who we know from a brain science perspective are capable of change, like Orlando has talked about, and who have demonstrated change, and who are ready and capable of living in the community and being integral to our success as a state, to address the intersections between our policies relating to how long and who we keep in prison, to how long and who we put through our post-secondary education programs. Who and how long do we help which families to stay housed, which schools to be well resourced. The list goes on and on about how issues intersect and result in this kind of egregious policy. And so this is doing, we have heard so long about the school to prison pipeline. Well, it starts well before school. And we have opportunities. We have so many opportunities to intervene along that pathway. And if someone has shown up on this list and they've been serving, some of them, an extremely long sentence for robbery twos in our state basically washed their hands of them. They gave up on them. They said, we don't need them. And in fact, all of that is false. It's a false narrative, but it still comes out today in hearings. It still comes out today in floor debate, where you have to listen to a partisan value. And unfortunately in our state, that's the only way these bills have passed, has been because of a strong Democratic majority. And it is a high value for our caucus to address systemic racism in all those points along that pathway where we can make a difference in providing resources to individuals and families so that we can reduce this unhealthy system of having people in prison for life.
Carla, Orlando, do you want to jump in on that, or we can move to the next question as well?
You know, I'm needing you to repeat the question. I'm sorry.
Okay, all good. Thank you. And so I'm curious as to why people have been resistant to this change and incrementally tweaking this this law. And if after this bill has been passed, if you think that all the unforeseen consequences of this law have been addressed or not.
Just to kind of speculate, I do think that people are generally resistant to change. I will say too that our office has been somewhat of an anomaly in this particular conversation, because we've been advocating for the change via our supporting these clemency, supporting 3 strikes cases where there's a robbery too as one of the strike offenses via the clemency process. So we were kind of advocating using sentencing reform, 3 strikes, criminal justice reform as a tool to let it be known how we felt about robbery 2 being one of the offenses on that strikes list. But I would say, and just listening to some of the conversation, and I haven't been at the center of these conversations, Dan Satterberg, my boss, has been the person that's been a part of those WAPA conversations. I think that sometimes change just can be difficult for Washingtonians. I don't know if you noticed it, but we seem to be a very incrementalist state. We're very methodical and slow about making change. We don't like to feel rushed. We like to study things for a long time. We're kind of nerdy in that way. So it's part of it seems to be part of the Washingtonian culture. Maybe that it can explain some of it. But yeah, I just haven't been so close to the political conversations to be able to add much to that particular part of your question.
If I can ask a question to Carla, has the phrase truth in sentencing been something that you as a prosecutor have heard? Because that's another narrative that we hear in the legislature, is that prosecutors make a promise to victims and they make a promise to communities that they're going to follow the law. And if the law, in Orlando's case, included him being in prison for life, then we just shouldn't cross that river. We just shouldn't change that law for him, because he knew what the consequences were and he was convicted of these crimes. And so that narrative of truth in sentencing is not new. I went back and I was reading a book by Martin Luther King Jr. and here he's talking, 60 years ago about this false narrative of truth in sentencing as being such a barrier to justice.
And that's true, and that's very consistent. I mean, that's part of the mantra that you will hear. You will hear about the truth in sentencing. You will hear about finality. Prosecutors are very connected to the truth in sentencing, very committed to that, very committed to finality, very committed to our victims. And I will say that in some of these cases, and it's usually the more violent cases where there's been significant injury. And as you know, with the robbery too, necessarily, you know, you're not, there's no, you're forcibly taking the property of another, but there's not necessarily any injury and there's no weapon involved, usually in these cases. But oftentimes people are concerned, prosecutors are concerned about the victims. Victims, you know, that voice and their response to this can be, it's hard for them to process these changes sometimes. But in my experience with notifying victims and the 3 strikes robbery 2, oftentimes the victims have forgotten about the event or have moved past it or support it or don't want much involvement, but you know, they're happy to be notified, or just simply trust our judgment. They may say things like, well, what do you guys think? I trust your judgment. Has the person changed? Have they transformed? As long as the person, as long as we believe the person will not commit the offense again, oftentimes I hear victims being supportive. But in the more violent cases, you don't hear that. Victims are very concerned about this process of resentencing, and they do want to be involved. And they do want to understand what their rights are, and they want to be able to articulate their feelings and their harm and how their healing journey has been complicated by, you know, whatever circumstances may have been going on in their lives, in addition to the harm caused. So it is very complex and it is a complicated conversation, but you're right, Senator. The truth and sentencing mantra, as well as the finality mantra, is some of the resistance that you will hear from the prosecuting attorney community.
All right, I think we can move to the next question. We have a question from Paige, who's asking, can you comment on how long generally the resentencing process takes for one individual? If resentencing can start in July, I'm wondering how long these roughly 29 cases will take or will wait.
Well, there's a lot of contingencies there, you know, the court's availability, but we've started at least with just having status hearings with the court to let them know what our intention is. And then after that status conference, we are scheduling the actual hearing. So I would say it can be anywhere from, you know, 60 days to 90 days. It kind of just depends, but that's just an estimate. And that will not include any process that DOC may have to go through before actually releasing the person. So I'm only speaking to the process as it relates to the court process. We're hoping that, you know, at least by the end of fall, we will have gotten through, you know, the majority of these cases, but it will depend on the court's just caseload and the availability of judges to hear these cases, but we will be prioritizing it.
Next question is from Nina. Carla, and I think it's a multi-part question. So Carla, could you talk a little bit about the judicial process? How much leeway do judges have in resentencing? Do they have to revert to the standard range for the crime formerly considered a strike? And do prosecutors have any ability to prevent resentencing or a standard range?
Yeah, so but under 5164, it's mandated that anybody who has that robbery 2 that resulted in that strike offense, they have a right to be resentenced. So the resentencing, based on what how the legislation reads, doesn't seem to be the question. It's just a matter of their sentence. What will their sentence be? They will be sentenced on their 3rd strike. So whatever the 3rd strike is, then they'll be sentenced there according to that particular crime, and whatever the standard range is, considering what their criminal score may have been, and those kind of factors will come into place too. So that kind of defines that a little bit. And, you know, help me out a little bit. Repeat the rest of the question. There was another part to it, Douglas.
Yeah. How much leeway do judges have in resentencing, and do prosecutors have any ability to prevent resentencing or a standard range?
We could definitely object to the standard range and make arguments as to whether there should be some kind of exceptional sentence. And that really will depend on what was presented at the time that the person was originally prosecuted for that particular offense. So there's a lot of different factors that go into play, but as the law has been written, it doesn't look like we have a lot of leeway here. And it doesn't look like judges have a lot of leeway, but there could be cases where there are some exceptional circumstances where there's an opportunity to object and there's an opportunity to maybe get a sentence that is beyond that standard range. But I think that will be rare. I don't know for sure, but I think that will be rare, and I think those will be exceptions. The majority of these cases will just proceed through and they will receive a standard range sentence based on that third strike, whatever that is.
Great. And I'm not seeing any other questions in the chat. So I think we can go ahead and start wrapping things up here. I'll just give it a few more seconds to see if anyone jumps in, but if they don't, I just want to say we're really grateful to one, Senator Darneille for joining us today. I know we've gone a little over time. We're really grateful for your efforts to champion this bill year after year in the state legislature and for all of your criminal justice reform efforts. Orlando, thank you so much for being here, sharing your story, and for the work that you're doing with the Freedom Project. And Carla, thank you, of course, for being here and for the work you're doing to really champion sentencing reform efforts here in King County. So if folks do have follow-up questions, you can feel free to reach out to me and I'll help track down those answers. But thanks to everyone for being here today. Thanks to the media for joining. I will be sharing a recording of this conversation after the call wraps up. So thank you, everyone. Have a great
afternoon. Thank you, everyone. Thank you, Senator. Thank you, Orlando. Thank you, media team.
Have a great day.
Nice meeting you, Carla and Orlando.
Nice to meet you too. Bye-bye.